In 1873, the federal government passed the Comstock Act, which made it illegal to send obscene, lewd, or lascivious materials through the mail. This included information about contraception. In the years that followed, 24 states passed laws making the sale or distribution of contraceptives of all kinds illegal. While these laws were rarely enforced, Estelle Griswold was arrested on November 10, 1961, for violating Connecticut's anti-contraceptive law after opening a family planning clinic in New Haven. In Griswold v. Connecticut in 1965, the Supreme Court decided that married couples have a constitutional right to obtain contraceptives, and that laws banning them violate a constitutional right to privacy. But there is no right to privacy mentioned in the Constitution, so where does it come from? In a famous passage, Justice Douglas wrote, "Specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance." A penumbra is a term that refers to an area of shadow that is created during a solar eclipse. What Justice Douglas was saying was that although we may not be able to see the right to privacy directly, we can infer its existence from other rights that suggest the framers were concerned with privacy. Specifically, the First Amendment guarantees freedom of association, and the availability of contraceptives helps individuals in structuring the most intimate form of association, a marriage. In addition, the Third Amendment prohibits the government from requiring people to host troops without the owner's consent, and the Fourth Amendment prohibits unreasonable search and seizure. Both of these provisions suggest the framers valued the right to privacy in one's home. The Fifth Amendment's guarantee of the right to remain silent also suggests that the framers thought that people had the right to keep things from the government. But the most important of all may be the Ninth Amendment, which specifically says that Americans have rights that are not mentioned in the Constitution. Writing in a concurring opinion, Justice Goldberg wrote, "Although the Constitution does not speak in so many words of the right to privacy in marriage, I cannot believe that it offers these fundamental rights no protection. The fact that no particular provision of the Constitution explicitly forbids the state from disrupting the traditional relation of the family, a relation as old and fundamental as our entire civilization, surely does not show that the government was meant to have the power to do so." Two justices dissented. They agreed that the law was bad. Justice Black wrote, "In order that there may be no room at all to doubt why I vote as I do, I feel constrained to add that the law is every bit as offensive to me as it is to my brethren." And Justice Stewart wrote, "I think this is an uncommonly silly law." However, they argued that although the law was silly and offensive, it wasn't unconstitutional. Justice Black said, "I get nowhere in this case by talk about a constitutional right to privacy as an emanation from one or more constitutional provisions. I like my privacy as well as the next one, but I'm nevertheless compelled to admit that government has a right to invade it unless prohibited by some specific constitutional provision." Justices Black and Stewart didn't think the right to privacy was a bad thing, but they argued that the majority misunderstood the role of a judge. They argued that judges shouldn't have the power to impose their own values on the Constitution, and that judges shouldn't invent new rights. Rather, if people want a right to privacy, they have the ability to amend the Constitution through the formal amendment process. Justice Black wrote, "I realize that many good and able men have eloquently spoken and written about the duty of this court to keep the Constitution in tune with the times. The idea is that the Constitution must be changed from time to time, and this court is charged with a duty to make those changes. For myself, I must with all deference reject that philosophy. The Constitution makers knew the need for change and provided for it. Amendments suggested by the people's elected representatives can be submitted to the people or their selected agents for ratification. That method of change was good for our fathers, and being somewhat old-fashioned, I must add it is good enough for me." Griswold was controversial, but it established that a right to privacy existed, and that right extended to contraceptive use. The question then became what other things the court would find protected under the right to privacy. In 1973, the court decided Roe v. Wade, one of the most famous and controversial rulings of the 20th century. In this case, they decided that the right to privacy includes the right of a woman to obtain an abortion. This decision was a source of political conflict for almost 50 years until the court reversed itself in 2022. The court's abortion cases are discussed in a separate video. In 1986, the Supreme Court decided Bowers v. Hardwick, which involved whether the right to privacy includes the right to sexual privacy. Like many other states, Georgia had a law criminalizing sodomy, which is oral or anal sex. This meant that it was illegal to engage in oral or anal sex even with your own spouse in your privacy of your own home. Due to a unique series of events, Michael Hardwick was convicted of having sex with another man in his own bedroom. He argued that the right of adults to engage in sexual acts is part of the constitutional right to privacy. In a very close 5-4 decision, the court disagreed. The court had become more conservative by this time, and it did not want to create any new rights. It wrote, "Hancock wants us to announce a fundamental right to engage in homosexual sodomy. This we are unwilling to do." Like Justices Black and Goldberg and Griswold, the majority argued that judges shouldn't impose their own values on the Constitution, saying that announcing rights not readily identified in the Constitution's text involves much more than the imposition of the justice's own choice of values. The majority noted that proscriptions against sodomy have ancient roots, and every state banned it until 1961. The dissenters disagreed, arguing that the fact that individuals define themselves in a significant way through their intimate sexual relationships with others suggests in a nation as diverse as ours that there may be many right ways of conducting those relationships, and that much of the richness of a relationship will come from the freedom an individual has to choose the form and nature of these intensely personal bonds. The court claims that its decision today merely refuses to recognize a fundamental right to engage in homosexual sodomy. What the court really has refused to recognize is the fundamental interest all individuals have in controlling the nature of their intimate associations with others. Then, a funny thing happened. Over the next couple of decades, the Supreme Court became more conservative, but in 2003, the court overturned Bowers by a 6-3 vote and declared Texas's law prohibiting homosexual sodomy unconstitutional. Justice Kennedy wrote, "To say that the issue in Bowers was simply the right to engage in certain sexual conduct demeans the claim the individual put forward. Adults may choose to enter upon this relationship in the confines of their homes and their own private lives and still retain their dignity as free persons. When sexuality finds overt expression in intimate conduct with another person, the conduct can be but one element in a personal bond that is more enduring. The liberty protected by the Constitution allows homosexual persons to make this choice." In addition to contraception, abortion, and sexual privacy, the court has also considered whether the right to privacy covers the decision of terminally ill individuals to end their lives. In a pair of decisions, the court decided that individuals do have a constitutional right to refuse medical treatment, including food and water. However, states can ban physician-assisted suicide, a practice that is now permitted only in California and Oregon. In addition, the court said that states can require a judicial hearing before ending medical treatment for a patient in a persistent vegetative state to ensure that ending treatment is what the patient would have wanted. In summary, the right to privacy currently protects the right to use contraceptives, to engage in private consensual sexual acts, and to refuse medical treatment. However, all of these rights may be under threat. The Supreme Court has already eliminated the right to an abortion. In a concurring opinion in that case and in other cases, Justice Thomas has suggested doing away with the right to privacy altogether. Conservatives on the court have the votes to make it happen. The only question is whether or not they will.